My name is Tom Dance. I'm a barrister at 1 King's Bench Walk, practising primarily in matrimonial finance. One of the main questions which arises in relation to trusts in matrimonial finance is whether it's a trust that will be variable. Now, as many people watching this video will know, Section 24 of the Matrimonial Causes Act only allows for a nuptial settlement to be variable. So the question will be, what is a nuptial settlement? The second question will be, what property is held within that nuptial settlement? There's been quite a lot of recent authority at first instance in the High Court about that question, and it's a relatively interesting one, on the basis that, on the face of things, in many cases, we as practitioners or certainly lay people would look at a case and think, well, if that property is held in trust, it must be the property itself that's subject to the nuptial settlement. Well, in a recent case, Mrs. Justice Roberts has held that it wasn't the flat itself that was the subject of the nuptial settlement, but it was the right to reside in the flat that was settled on the wife, and that was therefore a variable trust. And the distinction of that, and that's through... I might start this again, sorry.
Okay, that's fine.
Sorry. My name is Tom Dance. I'm a barrister at 1 King's Bench Walk, practising primarily in matrimonial finance. One question arising in trusts in matrimonial finance is whether that trust itself or the terms of it are variable. As practitioners watching this may know, a trust is only variable where it's classified as a nuptial settlement, where it's nuptial in character. And there has been a lot of authority on that over the course of the last 30 years or 40 years, and extending beyond that prior to the Matrimonial Causes Act. Once we have established that a trust is nuptial in character and therefore subject to variation, one crucial question is what is actually within that trust? What property has actually been settled on trust? Now, in the case of a property, say a flat in London, the question would seem obvious, the answer to the question would seem obvious, which is, well, it's the flat, and therefore that flat can be varied, the trust can be varied, and the flat transferred to the husband or to the wife or to anyone. That is not quite right, and we need to be careful as practitioners to have a real think at the beginning as to whether it's, in this instance, in this example, a flat that is subject to variation. Oh, no, I've got that wrong. I'll start that one more time.
Okay, we're rolling again, so go whenever you're ready.
My name is Tom Dance. I'm a barrister at 1 King's Bench Walk, practising in matrimonial finance. One key question in trusts in matrimonial finance is whether that trust is capable of variation. As most practitioners watching this will know, a trust is only capable of variation under the Matrimonial Causes Act if it is nuptial in character. It's a nuptial settlement. There are many authorities on what nuptial means. It's not defined in the Act, and those authorities span a number of decades, even prior to the Matrimonial Causes Act itself. Once we've established that a settlement is nuptial in character and can be varied, the question becomes, and an important question, becomes what property is actually settled. Take, for example, a flat in London. The answer might seem obvious, that the flat itself is the property that has been settled on trust, and therefore that flat could be transferred to the wife or to the husband. However, the answer is not actually always that simple. And if one looks very carefully at the terms of a trust, especially if it's not a trust with a very clearly defined trust document or trust deed, in many cases, actually, the property settled on trust is less tangible. Is, for example, as in a recent case dealt with by Mrs. Justice Roberts, the right to occupy a property as opposed to the ownership of the property itself. In that case, Mrs. Justice Roberts found that 2 flats in London occupied by the wife and children were settled on trust, but only the right to occupy those flats, whereas the actual legal and beneficial title to those flats was held elsewhere. Now, although the substance of her decision was overturned on appeal, that is an important question, and one which from the very start is crucial to consider, because as practitioners we would not want to run a case from start to finish only to find that a judge suddenly considers, unbeknownst to us or unthought about by us at a final hearing, that it's not actually the flat that's held on trust but the right to occupy the flat, because that hugely limits the orders that a judge is able to make in the circumstances. And in reality, if the judge can only vary the right to occupy, because that's what's settled in trust, then that may be of very limited financial benefits to your client.